You're listening to Alan Baird with Thursday Drive on Adelaide's 88.7 Coast FM, proudly sponsored by Rosa Lawyers of Torrensville and Campbelltown. And I'm now joined by the principal of Rosa Lawyers, Dino Rosa himself. How are you, Dino?
Yeah, very good, Alan. Hi to all your listeners. It's great to be here again talking about law stuff.
Law stuff, yeah, I like it. Now, this week I want to talk to you about personal injury and how a lawyer can help. I guess the most frequent instances of personal injury would be a car accident, and if you're involved in a car accident, that's not your fault. Perhaps a rear-end collision whilst you're sitting at a set of lights. What are the options that are open to you there?
Well, you can claim for injury arising from a car accident in South Australia, which is dealt with under the state legislation and in almost all cases by the Motor Accident Commission and who are the compulsory third-party insurer in South Australia, and they're currently managed by Allianz Insurance. If you've been involved in a car accident that is due to the negligent driving of the other driver involved, that's an important issue. It's got to be the other driver's fault. And the other important issue is if you've suffered injury, Allianz will ask you to complete a bodily injury claim form, and that's particularly if you contact them yourself without a lawyer. However, as I always say, you should seek the advice and representation of a lawyer from the start, as the lawyer can notify Allianz of your claim instead of you completing the claim form and deal with Allianz direct. And from there, the lawyer will be able to advise you of the various types of damages you can claim, including non-economic loss, past and future economic loss, if your capacity to work is affected, medical expenses, other expenses, lost superannuation benefits, cost of assistance from family members, and part of your legal costs paid, if not all. And basically the lawyer's role is to get the most you can possibly claim from these forms of damage, which we call heads of damage.
So what's the disadvantage if you deal direct with Allianz?
Well, if you deal with them direct, they will invariably dictate how the claim is managed. And while they may pay for medical reports for your injuries to assess your damages, their job is essentially one of damage control. And that's just par for the course for insurance companies, which means they will try to limit the amount of that they'll pay you out on.
Okay, so let me understand that your medical, lost wages and related expenses are covered by the third-party insurance in a car's registration. Do you get anything for pain and suffering? You know, the sort of things that I inflict on people in this radio program?
Yeah, absolutely. Yes, you can claim for pain and suffering, not just marital pain and suffering, but which is under the head of damage that are referred to as non-economic loss.
Right, okay.
Also known as general damages, which apart from pain and suffering also includes damages for loss of enjoyment, loss of amenities of life. This will also include, mental anguish that you've sustained as a result of the accident, disfigurement, reduced life expectancy, nervous shock, and those sorts of things. And these types of damages are assessed on a scale. It's very unscientific. It's a 0 to 60 scale, so 0 is no injury, 1 is, basically a slight bruising and a sprain, whereas 60 is catastrophic, near-death, vegetative state sort of injury. So most accidents involve a whiplash type of injury. They're known affectionately in the ambulance chase and caper as whippies. And usually up to about 10 on the scale.
No relation to Mr. Whippy, I'm sure.
No. Or other whip type places. And so it's basically worked out on a scale, so 0 to 60, and then that figure, whether it's 10 or whatever, it's then multiplied against a prescribed amount. So if you had an accident in 2008, the prescribed amount was $1,324, and if your injury is worth 10 points on the scale, that means you get $13,240 for that part of your claim. Okay.
Right, that makes sense, yeah. So what happens if your car, if the car that hits you is not registered and the person driving has no assets? You can't, they're not worth suing. Is it just a case of bad luck?
No, not at all. If the other driver was unregistered and therefore uninsured for third-party bodily injury, you can still claim against the nominal defendant, which is like a sub-branch of the Motor Accident Commission, which covers this type of situation, so everyone's covered.
Okay.
It also covers a situation in which you are the subject of a hit and run and can't identify the other driver of the car or their car.
So that's an instance I hadn't thought of, actually.
Yeah. So if you're injured by an unidentified vehicle, not a UFO, you must, to successfully claim damages for personal injury, you've got to satisfy the court that reasonable steps have been taken to identify the vehicle. And you must still be able to show that the injury was a result of the other driver's negligence. So that can be difficult. So making a claim against the nominal defendant is tricky, and you should get specialist legal advice and representation.
Yeah, obviously, that's a tricky sort of area, isn't it? So is there a time limit on making a claim for a motor vehicle accident?
Yes, there is. It's statutory. So, in other words, Parliament has enacted an act called the Limitations of Actions Act, another pot boiler. It's a 3-year time limitation period, and that applies to all claims for personal injury arising from car accidents in South Australia. This means you need to file your claim in the appropriate court within 3 years of the date of the accident, and that's if your claim, of course, can't be settled with Allianz in the meantime. If you don't do it, you're effectively statute barred.
Right.
And if you're under 18 when you suffered the injuries at the relevant time, then that 3-year limitation period starts from when you turn 18, so it's a bit longer.
That's the difference, yeah. Let's turn our attention to personal injuries. When it comes to, say, someone calling at your door, it might be a collector for a charity or one of those encyclopedia salesmen. He's called at your home, and as they leave the property, they trip over the hose on the path. What happens under those circumstances? Are you liable personally?
It can be, definitely. This area of law is referred to as occupiers' liability and is generally covered under the Civil Liabilities Act. When someone is injured by something dangerous on private land, the occupier can be liable because they determine who comes onto their property and how their property is maintained. So in the case of a collector for a charity, they need to step. They would, of course, need to step onto your property to get to your front door and ask you for money. They're there for a legitimate reason, therefore, and if they trip over the hose you have left menacingly across your path because you're too lazy to roll it up and put it away, and they suffer injury, then it's potentially your fault.
Right, okay. Can you avoid liability if you have a sign on the front gate that says no callers or hawkers or whatever? Does that get you out of that?
Good question. Good question. If the hawker steps onto your property despite your sign, they're particularly intrepid. They're technically a trespasser, and you then do not owe them a duty of care unless their presence on your property was reasonably foreseeable and the dangers were such that you should have taken precautions to protect that person. So in this case, it depends on the size of the sign and the danger posed by the hose. Not the pantyhose, but the rubber hose.
A violent hose.
Yeah, violent hose, yeah. I think it is foreseeable that a hawker would miss seeing your sign and trip over your hose, so you might still be liable. But if let's say you have a big sign that says no entry, demolition in progress, and the hawker ignores it and then gets hit by some falling masonry because you're doing work on your own old villa or something, you could argue that they have been warned and therefore you may not be considered liable.
Right, okay. I guess that's a good reason for having home insurance, to make sure you've got that cover, yeah.
Insurance.
So let's look at another situation. The person knocking at my door is an uninvited caller and is bitten by my Alsatian dog as he runs for his life back down the garden path. What happens there? Is it the same sort of idea?
That's an even better question, Alan. The law in this area is regulated by the Dog and Cat Management Act, 95 in fact. That's pretty dog-eared. Bit of legislation. Under the Act, the dog owner is responsible for any injury, loss or damage caused by their dog. The injured dog does not have to show... Sorry, the injured person...
Yeah, well, the dog might get injured.
Absolutely, yeah. There might be a trap for it. Yeah. The injured person does not have to show that the dog owner was negligent or knew that the dog was vicious or dangerous. Now, if the person coming onto the land is a trespasser, for example, a burglar, or an encyclopedia salesman, the dog owner may not be held liable, but a common or garden uninvited caller, like a charity worker, will almost certainly be able to make a claim against you if he's confronted by your Cujo or Rin Tin Tin or whatever, and thereby suffers an injury.
Now look, we hear a lot about medical negligence, and it's very popular in the US, where I spent some time a few years back. Are you seeing more claims of that nature here in Australia now?
I'm not sure if I've got any statistical evidence, but anecdotally, I would say that medical negligence is definitely on the rise in Australia, and I don't think that that's because doctors are getting worse or or anything like that. I just think that this is because people are much more aware of their rights. And, you know, in this day and age, people are just more willing to point the blame or point the finger at someone. But in case of medical negligence, this is really, really hard. It's a really hard area. It's definitely the most complex area of personal injury law. It's very hard to determine whether a person has a strong negligence claim when you first see them. When I first see them in my office.
Right.
Because you've got to get an expert opinion from another doctor stating that in their opinion, the treating doctor was negligent in some way. There are cases where negligence is more readily provable, like the doctor death scenario, but most medical negligence cases are extremely difficult to pin down because of what we call causation issues.
Yep.
If someone's sick and then they get it operated on, it's sometimes very difficult to discern whether it was the doctor's fault or the fact that the person was sick or had a life-threatening issue. Sometimes you might need to get an opinion from a top doctor interstate or overseas because there is simply no one available in Adelaide or even Australia to help with an opinion, and that way it's the only way you can be absolutely sure that the expert is available, that an expert is available who can give an opinion without fear or favour. So it is hard, and running up costs of those types of claims is much larger than your standard sort of car accident matter.
Right. Well, look, that's our time gone again, Dino. So thanks for coming in and shedding some light on the subject of personal injury and how the law can help us. It's actually good to have someone who can explain these topics in simple English. So I thank you very much for that.
Optime furit absolutus voluptatem.
And?
That's Latin for thank you. It's been an absolute pleasure.
Oh, look, you're a coward. That's great. That's great. I really like that. Okay, thanks again, Dino, and we look forward to joining you next week. And, of course, if you do have an area that you would like to have discussed by Dino, then certainly send an email to me at thursdaydrive, all one word, at coastfm.com.au, and Dino will join us again next week here on 88.7 Coast FM.